developer's absolute worst nightmare.
Oh, yeah.
Imagine this. You have a massive project. 59 apartments, maybe halfway built.
Millions of dollars are already sunk into it. Buyers are probably lining up.
And then, bam, a court order just freezes everything. Solid.
All because some distant relatives just show up out of the blue.
Exactly. They pop up claiming they own the land because of a family adoption that supposedly happened 50 years ago.
It sounds unbelievable, but this is the real story behind a 2006 Supreme Court case, MGurudasvRasaranjan.
It's just such a fascinating clash, isn't it? You have this high-stakes economic reality on one side.
And this really complex old family history on the other. It all goes back to a man named Obalapa, who died way, way back in 1949.
But he's not even the main person here, really. The whole fight is over a woman named Nirmala.
Right, so the builders, they argued she was just Obalapa's niece, his brother's daughter.
Which, if that's true, means she's entitled to a tiny, tiny piece of the property.
A very small fraction. But her heirs come along and say, no. Nirmala was actually adopted by Obalapa back in 1947.
And if she's the adopted daughter?
Well, then they get a massive share of this multi-million-dollar property. It's a huge difference.
So, of course, they rush to court. They want an injunction to stop the construction immediately.
The temporary injunction, yeah. And, when we talk about stopping a project like this, we usually look at what's often called the Holy Trinity.
Right, under Order 39 of the Civil Procedure Code. So that's the Prima Facie Case,
the balance of convenience, and irreparable injury. Those are the three big tests.
But this is where it gets really interesting because the court looked at these in a very historical way.
Yeah, let's just take the first one, the Prima Facie Case. At first glance, is there a real triable issue here?
You'd think so, but the timeline itself was their biggest problem.
Their absolute enemy. Because the alleged adoption they said it happened in, that date is just.
Yeah.
It's fatal to their case. Because under the old uncodified Hindu law, we're talking before the big legal reforms of 1956, the adoption of a daughter was generally considered invalid.
Really? So you mostly adopted sons?
For the most part, yeah. You adopted sons for, religious rights to continue the family line. So claiming a daughter was adopted in 47 was legally shaky from the get-go.
So that weakens their case right away. And then they had another big problem, didn't they? They couldn't seem to keep their story straight.
Not at all. You look back at an earlier legal proceeding in 1987, and Nirmala is described as a natural daughter.
Okay.
Then fast forward to 2000, and suddenly the story changes. Now she's an adopted daughter.
And the Supreme Court did not like that one bit.
They took a very strict view. See, an injunction is what we call equitable relief. It basically means you're asking the court for a special kind of help.
And for that, you have to come with clean hands.
Exactly. You can't just prevaricate, flip-flop on your main narrative and expect a court to freeze a commercial project for you.
Which brings us to that second test, right? The balance of convenience. Who gets hurt more?
And in a case this big, it's not just the builder versus the family. You've got 59 other parties involved.
The people who actually bought those flats.
Buyers, yes. The court weighed that very heavily. If you stop construction, the building just sits there and deteriorates, the buyers are left in limbo.
The economic value is just destroyed for everyone.
Whereas if you let construction continue, okay, the family might lose out on the physical land, but
they can be paid. They can be compensated with money.
Precisely. So the court came up with this really pragmatic solution, a bit of a Solomonic verdict.
Okay, so they didn't stop the project.
Yep. They vacated the injunction, they let the sale of the flats continue so the project wouldn't die.
But what about protecting the family's claim?
To do that, the court ordered the builders to take half 50% of the profits from all those sales.
And do what with it?
And lock it away in a bank deposit. To just sit there, untouched, until the main trial finally concluded.
Wow. So it effectively secures the money for the family without completely killing the project.
It's the playbook, really.
Yeah.
For any legal pros listening, the big takeaway is to leverage that balance of convenience. Argue that financial security is a better remedy than stalling progress.
And for the rest of us,
the lesson is pretty simple. Don't sleep on your rights for decades. The court has very little patience for claims that just suddenly appear half a century later.
It really forces you to ask a bigger question, though. Is cash always a sufficient substitute for land? The Supreme Court basically said yes here to save the economy.
But in doing that, they effectively turned what the family saw as their property right into just a financial claim.
A really fascinating point to mull over. Thanks for joining us on this deep dive.